Let's see. So I did bring a copy of the newsletter, and the reason I did this is we do put a lot of information in it. It comes out quarterly. It comes out, it just came out the first week in October, and we started with about 8 pages. We're up to about 28 pages of information, and if you haven't signed up for it, it's electronic. You can get it right to your home automatically, and you can see me after on how to sign up, but it's online on our website. We also keep copies of it. It's a great document. We try to keep information in there that will keep board and commission members updated, residents updated, businesses on things that are coming up and initiatives. So please, if you don't have one, help yourself. And right on that, there are instructions on how to sign up. Likewise, on that, we also, on our website as well as on our newsletter, we post any kinds of vacancies that we have, committee vacancies, openings, so we make sure that people are aware that we do have slots open and we're encouraging volunteers. So to get started, just want to thank you all very much for being here tonight, and especially for volunteering on behalf of the town. There are many boards and commissions that we need to fill. As you all know, it's hard to find people who have the time or the availability to participate in these committees. And some committees are extremely time-consuming, some of our regulatory committees, and others also are time-consuming because they're trying to meet short deadlines for recommendations back to town administration. So we're grateful to have you, always looking for volunteers. We try to place people on boards and commissions that meet their interests as well as their background. So we do have an application that you can do online. You can fill it out in our office. There are a couple of different appointing authorities, as you know. The Board of Selectmen appoints the Finance Committee and the Zoning Board of Appeals. And then the town manager under the charter does appoint other boards and commissions. So why we're here tonight, we started a couple of years ago with an annual board and commission training because we wanted to be able to give you as board and commission members tools and opportunities to ask questions of town council and town administration, tools to help you do your job, tools to make it as easy as we can for you to participate on boards and commissions. Where do you go for resources? How do you find them? What's your role as a board member? How does it relate to town administration? How can we work together to move Auburn forward? So we developed an annual training, and it pretty much has the same components every year, and Bob Hennigan will be going through this with you, but the open meeting law, the conflict of interest law, Robert's rules, those are standard. And then we try to address some commonly asked questions, like the FAQs, the frequently asked questions that we get as town administration from board and commission members throughout the year that we thought we would put them together and then come back to you as a group and let you know what some of the questions are that your fellow board members are asking and what the response is, and hopefully that will help you. If we're not giving you all the information you need, if you want to talk to us privately at some point, that's fine. If you want to ask questions specific to your board or commission, that's okay to do. If it's specific to your situation, I'd probably recommend that you speak to us after, you know, if it's a question about a conflict of interest or something, again, happy to speak to you about that. There are certain provisions of the charter and bylaws that impact board and commissions, so we want to make sure that we go over that with you this evening. And we want to, again, give you opportunities to ask questions of us. So over the last few years, we've worked really hard to help our volunteers and our board and commission members, as many of you know, by providing trainings like this. We also, I believe it might have been in the fall last year, in March, we provided what we call ALICE training, which is a training available to board and commission members on how to be prepared and give you some tools and techniques. Should there, horribly so, but it does happen, but should there ever be an incident where there is either a gun or a knife or some type of an incident in a public meeting, how would you handle that? How can you protect yourself? And we want to make sure our board and commission members are trained in that. So we did provide the ALICE training that was done through our police department and our fire department. All the town employees have also received it, as well as the school department employees. So we're trying to be as prepared as we can. Unfortunately, in this world, there are things that happen, and they tend to happen in public places, and we just want to make sure that we've given you the tools that you will need to make good decisions if something like that should ever happen. I also want to just make a note that we have a couple of our department heads here as well. We have a new library director here. Jean Collins is the library director. She's here this evening. And our town clerk, Deb Grimo, is here. And I see Darlene Coyle, the director of the Department of Development and Inspectional Services. All of them, in some capacity, work with a board or commission or several. So they're here as well to listen to the information so they can, at a later date or tonight even, if you need to, answer any questions that you might have. So just a couple of other things, and I'm going to turn it over to Bob. Just boards and commissions are pretty much two different, there are two different types. One is advisory, meaning the board and commission meets to discuss certain issues that have been assigned to it, to fulfill a certain mission or an agenda, and to maybe in some cases make one specific report and report back on that. Most recently we had a committee called the Elementary School Reuse Advisory Committee. They did a phenomenal job of looking at Julia Bancroft and Mary D. schools and giving a recommendation to town administration as to what to do with those facilities when they were declared surplus. That was a specific advisory committee. Then there were regulatory committees. That would be Board of Health, Planning Board, Conservation Commission, Board of Appeals. I don't think I missed any on the regulatory side, but forgive me if I did. Those have to follow and comply with Mass General laws and ensure that applicants in front of them are complying with those Mass General laws as well as local bylaws. So we want to make sure that all of our boards and commissions are well prepared to handle it, whether you're advisory or regulatory. And we say this all the time, but sometimes someone coming into Auburn, whether it be a resident or a business that's coming before a board and commission, the only interaction they may ever have with anyone in the town may be your board or commission. So we want to always make sure that the boards and commissions are professional and respectful, and likewise, we as employees want to do the same thing. All the employees have been through customer service training. We've all been through several different types of training. We want to give good service to our residents and to our businesses. And you as board and commission members have been, and we thank you for doing the same thing. We get very good feedback from the businesses and residents who come to this community who have actually made an effort to call our office and comment on what a great experience they had. It doesn't necessarily mean their project got approved. It means that they got help, they got good guidance, and they know what direction they have to follow. So we just want to make sure we thank you, because it does get noticed by people, and it's much appreciated. I think the last thing I just want to say, I want to turn it over to Bob. One of the things that we just have to remind, and this is a frequently asked question, board and commission members under state law are municipal employees. So whether you're paid or unpaid, if you're a volunteer, as an appointed or elected official, you're considered a municipal employee for purposes of conflict of interest law and open meeting law. So that's why we think it's important that we give this training to you, give you the resources that you need so that you can move forward on it. Bob's going to go through a couple things with you. Ed and I can go through a couple of things that we want to bring to your attention as well after Bob goes through kind of the standard things. Just to let everyone know, and it affects some of you and some not, but we did go through a major process. It was about 3.5 years to update the general and administrative bylaws, and they were approved at town meeting in March. We received approval from the Attorney General's office October 9th, and the Board of Selectmen just last week, and I noticed that we have two selectmen here, Dan Carpenter and Chairman Ken Holstrom. They approved the fees and fines that are affiliated with the new general bylaws. So that does affect some of your boards and commissions, because people will come in and have applications. There were fees for certain things, and there were fines for violations. So those will become effective this Friday. They have to be posted in a publication of general circulation in the town to be effective. So we have about 1,000 of them going out in the Auburn News on Friday's edition. They'll also be on our website, and they'll be posted in individual offices, so you can see those new fees and fines. Some of them hadn't been updated in years. Others never existed. We had some of our bylaws, there was no mechanism for enforcement. There was no way to keep people doing what they should be doing. So we've implemented fines where we can. So there's again, these schedules are going to be online. It may or may not affect your board or commission, but I just wanted to let you know that it is there. So I'm going to turn it over to Attorney Hennigan. Thanks.
Thank you, Julie. For those of you who've been here before, I always start off by saying this is going to be a very exciting night. It's very, very exciting. And if you've been here before, you know I'm making that all up. But it's actually pretty good with some pretty good information. Does everybody have the handout that... everybody has it. Presumably that's the answer. So I want to start off by just talking a little bit about open meeting law, which is really not going to be any different than probably the last time we spoke. And we do this simply because if one has an understanding of the role and the purpose of the open meeting law, you can kind of understand what its rules and why there's such regulations over it. So just to begin on my outline, if the purpose of the open meeting law is clearly simply to ensure transparency and to ensure that deliberations made about public policy are done in a transparent fashion. The democratic process, does require the public to have knowledge of whatever public policies are being considered, and as a result, they have a right to be present during any deliberations of those public policies. So it's important for everybody who's on a board or commission to understand what meetings are covered under that open meeting law. It's very, very clear, all meetings. If you're on a board or commission, just consider every meeting that you hold is a public meeting, and it must be open to the public. It's generally defined as a deliberation by a public body with respect to any matter within the body's jurisdiction. It's a very broad definition, and for boards and commissions, it almost applies to everything you do. The issues that become involved here are what do we mean by actually meetings, what do we mean by public body, and what do we mean by deliberation. So what constitutes a public body is a multi-member board, commission, council, authority, or committee of a town which has been established to serve a public purpose. So if the board you serve on is involved in serving that particular role of providing a public service, that board is subject to the open meeting law. The law also includes any multi-member board that's created to advise, as Julie talked about earlier, or make recommendations to a public body. If that's the instance, if that's the situation you find yourself in, that is a public body that is required to meet the requirements of the open meeting law. Perhaps sometimes what becomes a little more difficult in terms of drawing a line as to whether the open meeting law applies or not, comes into the question of what constitutes a deliberation. And the statute very clearly defines what a deliberation is. It's an oral or written communication through any medium, and I think we'll go back and talk about that in a minute, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. So if you look at that and you break that down, oral and written communications are pretty simple. It's the electronic mail issue that becomes the problem, and that includes emails, that includes texts. Any effort to conduct a meeting by electronic mail or text with a quorum of a public body on a particular point of business would not be allowed under the open meeting law. And that includes any kind of decision-making of any kind of that particular body. What doesn't apply is distributing a meeting agenda, scheduling information or procedural information, or other documents necessary for review by a public body, provided they do not express the opinion of a member of the public body. So if it's simply informational, you're passing it along, electronic mail is certainly appropriate. It's when you get into the issue of discussing what people's thoughts are, what their position is, what they want to do, that's where you get into an issue that's that type of deliberation that is required to become and remain transparent. So let me just emphasize that email exchanges between or among a quorum of members of a public body discussing matters within the body's jurisdiction may constitute deliberations, even where the sender of the mail does not ask for a response from the recipients. So you got to be very, very careful about what it's done in terms of email. If you could avoid it entirely, that's what I would recommend that you do. Another issue that often comes into question is what's involved in terms of filing or posting notices of meetings. And the law, again, is pretty clear in this, is very clear in this. Except in cases of emergency, a public body must provide the public with notices of its meetings 48 hours in advance. And those notices must be filed with the municipal clerk sufficiently in advance of a public meeting to permit posting of the notice at least 48 hours in advance. I emphasize that it has to be a publication of a notice. It can't be just, some kind of an indication to somebody in the clerk's office or something that by telephone call that you're going to hold a meeting. If your commission is going to hold a meeting, you need to provide the clerk with an actual notice of your intent to hold that meeting so that it can be posted within 48 hours. And the information that must occur in that particular meeting is identified in my next section. What information must meeting notices contain? Meeting notices must be posted legibly, easily understandable format. They have to contain the date, time, and place of the meeting, and list the topics that as of the time the notice is filed, the chair reasonably anticipates will be discussed at that meeting. So you have to keep in mind the role of the chair in all of this. The chair sets an agenda for the meeting. The chair can only set an agenda for the meeting if the chair reasonably knows about that particular item being discussed. If the chair doesn't know about it, it doesn't get on the agenda, and it can't be discussed. Unless, in certain circumstances, situations arise where one could suggest that the item has to be handled expeditiously, and it could be determined with a reasonable degree of certainty that the chair did not reasonably anticipate that it would be necessary to have discussed and therefore wasn't on the agenda. The topics must be sufficiently specific to reasonably inform the public of the issues to be discussed. And the public bodies are encouraged to make a revised list of topics to be discussed if the body intends to discuss the topics that come up after posting. So if something does come up, it's a mistake, if it's inadvertent, and you need to discuss something, it becomes okay to repost it or to prepare the agenda. Of course, you cannot add items to it that you could not reasonably anticipate. Recently, well, not recently, I suppose now, but a few years ago, the Attorney General's office wrote an opinion on such a situation, and I just wanted to read this so you'll understand the importance of this notice issue, because it goes to the issue of transparency, and it goes to the issue of the public knowing what a body is going to talk about, and it goes to the whole idea of deliberation of public policy. So the Attorney General's office, upon receipt of a complaint from a neighboring town, but I won't tell you who it is, it says the open meeting law prohibits a public body from considering any item that was not listed as a topic in the relevant meeting notice and that was reasonably anticipated by the chair 48 hours in advance. While a public body may consider a topic that was not reasonably anticipated by the chair, our office strongly encourages the public body not to consider topics that may be controversial or of a particular interest to the public until the topic has been properly listed in a meeting notice in advance of a meeting. So I think what the AG's office is simply suggesting there goes back to the whole idea of transparency, and that if it's not an emergency, if it's not something that came up at the last minute that needs immediate attention, and if it's controversial of any way, shape, or form, and perhaps even if it's not controversial, it's better to wait and put it on at the next meeting before making a decision as to how to proceed. The exception to all of this comes into the issue of executive session. And as I've said before, oftentimes executive sessions are not going to appear at boards and commissions, although they could. And if they do, I just wanted to touch upon the procedure that a chairperson or someone sitting in the chair or someone on the board may want to consider an understanding in terms of how to proceed. An executive session is there are 10 statutory exemptions to meeting in public, and you have to meet that statutory exemption before you can go into executive session. But the meeting has to be first convened in open session. The meeting then has to state, the public body has to state the reason for the executive session, citing, in our opinion, the statutory reference that applies in this particular case, or stating all the subjects that may be revealed without compromising the purpose for which the executive session was called. Should state whether the public body will reconvene at the end of the executive session. It has to take a roll call to enter into executive session, and while in executive session, the public body must keep accurate records and must take a roll call vote of all votes taken. Here's a key part. It may only discuss matters for which the executive session was called. It happens so very many times that you're in an executive session and you're talking about the issue that applies, but natural course of conversation of people is that it will divert to another area, and before you know it, you're off the topic for which you voted in. That really has to be controlled, and is often controlled by the chair, who really must keep it online as to the purpose for which the executive session was called. The executive session, like I said, there are 10 areas. I won't go through them. If you were going to go into executive session on a board or commission, my sense is that you would, perhaps you would consider calling Julie and telling her that you think you might need an executive session, and then she might call us and we might be able to help her out at that point in time. In terms of records that you have to keep, however, here's what the statute says. The records you're required to keep and maintain accurate minutes of all meetings. The minutes have to state the date, the time, and the place of the meeting, a list of the members present or absent, and the decision made and actions taken, including a record of all votes. While the minutes must also include a summary of the discussion on each item, a transcript of that is not required. So you're not required, who's ever taken the minutes of your board or commission, to verbatim record, although I've seen some boards and commissions do that. You're not required to take a verbatim record of what's discussed. You are required, however, to keep a record of a summary record of what was discussed and the votes required. No votes can be taken by secret ballot. And the minutes must include a list of the documents and other exhibits used at the meeting. So if there are documents that are presented by anybody who's participating in that discussion, and if they become part of the record, those records have to be included as part of the minutes of that particular meeting. The open meeting law requires public bodies to create and approve minutes in a timely manner. Of course, they don't define what timely manner means, so you have to use your best judgment. Sometimes it's impossible for minutes to be approved for a variety of reasons, but as soon as you possibly can approve minutes of a particular meeting, we encourage you to do so. But approved minutes also have to be filed with the clerk's office, as you know. The existing bylaw of the town, which will be in effect until Friday, as Julie says, in Chapter 3, Section 21, states that all boards, committees, commissions, etc., elected or appointed, standing or ad hoc, shall keep minutes of each meeting, and a copy of said minutes shall be sent to the town clerk within 2 weeks of their approval. And that has also been continued with the new bylaws which come out on Friday, which is Section 3.03. Again, it says the public body shall maintain records of all meetings, and that, again, there's the requirement to submit them to the town clerk's office within 2 weeks remains. So that's an obligation that the board both has under the bylaws of the town. Public records of committee meeting, any minutes or any documents submitted in something that is not in an executive session are all public record. and the law requires that those records be made available to the public within 10 days of any request that was made. Many, many times requests come into the town manager's office rather than directly to a board or commission. But if a board or commission member receives a request for public documents, I would recommend to you that you contact Julie and proceed as she so advises. A couple other things. There is an issue of remote participation, which I think Julie is going to talk about briefly when I'm finished. But the statute does provide for a procedure for adoption of remote participation, which appears to be underway. The town bylaw still requires an itemized report to be submitted. I'll just read to you what the new section is. The new section states this: it's an annual financial liability report. And it says that the town manager shall require that all boards, offices, and standing committees annually, before the first day of August, submit to the CFO an itemized report in writing of their activities for the preceding fiscal year. This statement shall include an itemized account of the liabilities incurred by that board, office, or committee, which are outstanding on the 30th day of June. These reports and the records of town meetings and elections held during the preceding year shall be printed annually in the town report. I'm sure that may or may not apply to every particular board or commission, but if you think it does, I would suggest that you do what I do every time I have a question. That's call Eddie. So it's just a simple way to get the answers. If you don't know, you just call in. A couple other things I'd just like to point out to people. In terms of the use of audio-video equipment, sometimes those issues arise as to whether someone can use audio-visual equipment. The statute talks about that very clearly. The public record law states that after notifying the chair of the public body, any person may make a video or recording of an open session of a meeting of a public body, or may transmit the meeting through any medium, subject to reasonable requirements of the chair as to the number, placement, and operation of the equipment, so as to not interfere with the conduct of the meeting. At the beginning of the meeting, the chair shall inform other attendees of any recordings. So again, I want to emphasize the authority that someone who's chair of your board or commission has to control that particular meeting. They control it through their very presence as being chair, but they also control it through whatever actions they take. So they can allow, and they have to allow, audio and visual recordings. However, they have control over that, and they should not be afraid to use that authority that they have in the statute. One of the statements that we have recommended, and I'll provide it again to Julie, is a statement that a chairman could use at a meeting if they don't know what to say about this particular subject. So it's simply that the chair, prior to the meeting beginning, would simply ask, is there any person making a video or audio recording of this meeting other than the one that would be allowed through the town at that time? If such video or audio recording is being made by someone other than the board or committee itself, you have to notify it, and if no such recording, the chair would simply state for the record that there are no other recordings. And I think that's a consistent, if people could do that, that would be a consistent way to handle that particular issue. That completes my little speech on open meeting law. Any questions on open meeting law? Told you it was going to be exciting. I just calm down. Mike.
Can I have the site for the last part you just talked about notifying?
Yeah, 30A 20 F. And and then I'm glad you raised the question because I realized I didn't follow up with another one, so you might want to refer to G also. In G, in the statute 38 section 20 states that No person shall address a meeting of a public body without permission of the chair, and all persons shall, at the request of the chair, be silent. All other persons, at the request of the chair, shall be silent. No person shall disrupt the proceedings of a meeting of a public body. If after clear warning from the chair, a person continues to disrupt the proceedings, the chair may order the person to withdraw from the meeting, and if the person does not withdraw, the chair may authorize a constable or other officer to remove the person from the meeting. Again, understand the power of the chair, that the chair has the authority to control the meeting. You can't speak without being recognized by the chair. If you do, the chair has the right and the statutory responsibility to control the meeting, and can take actions necessary if the control of that particular person doesn't stop. So, Mike, that's 3820F, 20F and G. Any other questions? So if you thought that was exciting, let me touch on conflict of interest law. So conflict of interest law is controlled by what is known as Chapter 268A. The thing I'd like you to understand, if you could, about the Chapter 268A is that it governs, it's not governing now the public body's conduct, but it's governing your individual conduct. And that's a point of major distinction, I think, because anything that your conduct could violate could be subject to civil or criminal penalties if you take a prohibited action. Sometimes conflict of interest, you inherently or intuitively think you feel like you're in a conflicted situation. If that's the case, you have the right to seek legal advice from the State Ethics Commission or Town Council regarding how a particular law might apply to, or the law might apply to your particular situation. So if from an intuitive position you feel like you might have a conflict of interest, I recommend that you get a hold of Julie, and perhaps she would recommend that you talk with our office, or she may recommend you talk to the State Ethics Commission itself directly, or she may recommend both, and you'd have the choice to do either. But here's the things that you have to keep in the back of your mind. You cannot ask for or accept anything of value if it is offered in exchange for your agreeing to perform or not perform an official act. You can't ask for or accept anything worth $50 or more from anyone with which you have official dealings. These would include sports tickets, cost of drinks, meals, travel expenses, gifts of any kind. You may not hire, promote, supervise, or otherwise participate in the employment of your immediate family or your spouse's immediate family. So, again, I don't know if that would apply in many situations for you, but just understand that if the situation and the stars align themselves right, that you find yourself in a situation where you might have an interest in doing something for a particular family member or spouse's immediate family member, you have to recognize that you might be crossing a line in terms of a conflict of interest. You may not take any official action which will affect the financial interests of your immediate family or your spouse's immediate family. You may not take any official action affecting your own financial interest or the financial interest of a business partner, private employer, or any organization which you serve as an officer, director, or trustee. Unless you qualify for an exemption, and the statute talks about certain disclosures that you could make that might allow you to be exempt, you cannot have more than one job with the same municipality or county, or more than one job with the state. You cannot have a financial interest in a contract with your public employer. And again, unless you meet certain criteria. You cannot represent anyone but your public employer in any matter which your public employer has an interest. This might be the one where it gets a little bit murky for people. And just recently, I think I brought it with me, just recently, there was a case out of Uxbridge where an individual on the Conservation Commission was involved in a situation where he was obviously a member of the Conservation Commission and also a member of an organization which was going to oppose a petition that was presently before the Conservation Commission. So I'll just read you what the Ethics Commission found and fined this gentleman $2,500, which he has to pay personally. That's not something that the town pays. It is something that the individual pays. So in this particular case, the individual on the Conservation Commission abstained as a Conservation Commission member, but then spoke on behalf of the organization that he also was a member of and represented. And he spoke to oppose an application for a notice of intent filed by another condominium organization, which was seeking to permit a permit to dam and divert a water course that flowed underneath its building. And the individual's building was downstream of that particular water flow. So this individual did not vote on it. Unfortunately, he spoke about it beforehand. And in that particular instance, by speaking on it on behalf of that organization, he was representing someone before a public employer in a matter in which his public employer had a particular interest. And the State Ethics Commission did turn out to fine him under an agreement of $2,500. You may not disclose confidential information, data, or any other material which you gain or learn as a public employer. You may not use your official position to obtain unwarranted privileges. You may not use public resources for political or private purposes. And finally, you may not, after leaving public service, take a job involving public contracts or any other particular matter in which you participated as a public employer. That's very complicated, and I will tell you, it is very complicated. It takes you need to understand the factual situation of an individual to determine whether this particular area of the statute applies. So what one might want to, for purposes tonight, just be aware that situations that you're involved in as a member of a board or commission today or in the next year might have some implication of what you could possibly do in the future on particular matters that you're presented with while you're a member of that particular commission. Again, if those situations were to arise, again, you would seek assistance from the State Ethics Commission, my office, or wherever you might be able to find some help. The one other area that this becomes kind of an area of concern is in fundraising. Oftentimes, public employees become involved in fundraising for particular reasons. So I would just tell you that the State Ethics Commission has ruled that you can't do that. They have said most of our opinions applying to these statutes and to these situations with public employees have involved solicitations for non-governmental purposes. We have explained that such solicitations are problematic for numerous reasons, including because they raise questions about the soliciting public employees' objectivity and impartiality, and may cause persons solicited by the public employee to feel compelled to comply. So in terms of your trying to raise funds for a particular organization, I would suggest that you do so with a great deal of caution while you're a member of a particular board or commission if those two interests begin to cross the line. If they do, my recommendation is that you just explain to someone that it's a conflict and it's not something you can participate in. And where that solicitation interest becomes a governmental purpose, where you're raising it not now for a nonprofit organization or for some nonprofit benefit, you're raising it for a governmental interest, you can only be allowed to do that if a statute allows you to do it. So in essence, you can't do it. So I probably could have said that very clearly if I started that way. Yes. Yeah. In practice, there's probably not a difference. I like to suggest to people that they recuse themselves, because to recuse yourself is an affirmative action on your part to stand up and say, I am not going to participate in this particular action. So I always suggest to people, if there is a situation where you need to take action to not involve yourself, put on the record that you're recusing yourself from that particular action. To abstain, you could simply sit at a vote and not take any action at all, and just not respond affirmatively or negatively or whatever. So it's less affirmative, in my opinion, on your part. So in terms of a conflict of interest context, my recommendation is you literally recuse yourself by putting on the record that you are not going to take part in that particular matter. And then, as I probably say with just as good time to say it now, my recommendation is, if you recuse yourself from a particular matter, stand up and leave the room. I know it sounds foolish, I know it sounds silly. You could go to the back of the room probably just as easy and not be involved. But I've read cases and seen situations where body language, people have gotten signals from body language from people or whatever, and you just don't want to be in that situation. Just recuse yourself, ask somebody else on the board to come get you when they're done, and recuse yourself, get it on the record, walk out of the room, and then nobody can make any questions about it at all. Thomas Jefferson just once said, in terms of talking about conflict of interest, whenever you do anything, ask yourself, how would you act were the whole world looking at you, and act accordingly? So if Jeffersons can say that, I figured I would bring that up and say it today. The final area is just a brief summary of Robert's rules, just again the conducting of a particular meeting. It really starts off with, again, what I said before. You have to have a chair. The chair has to recognize the chair's role. The role of that chair is to set the tone of the meeting and set the setting of the meeting, and making sure that the meeting is controlled so that everybody can hear the discussion. It makes no sense to have a transparent, open meeting and deliberating over public policy if no one can hear you. So the chair's obligation is to conduct all those things. But then the chair's obligation is to process any particular motions that are made. And those motions usually come in a time of a particular vote on a particular matter. So we simply suggest that when a motion is made, it be seconded. When that motion is then seconded, even though you may have had 2 hours of discussion on that same particular matter, what is before that particular body at that point in time is an actual vote of how to proceed on a particular issue. That's the motion, which has been seconded by someone. Now you could have a discussion on that particular motion, and sometimes there is none because it's already been discussed, but it should be at least offered that there be some discussion. There could be further debate and deliberation, clarification, and then if there is none, then you would proceed to a vote. Oftentimes someone might want to amend a motion. That requires a second. You can have discussion on the amendment. You then vote on the amendment. If it passes, it becomes the original motion as amended, and if it's defeated, the vote taken is then made on the original vote. And the last area was the abstaining from voting, and I usually talk about the recusal in there, but we've already talked about that, so I don't have to go into that at any particular time. I was trying to keep within my time limit. Julie has an item here that I noticed of, I don't know where it is. Oh, here it is. Requirements under Auburn's general administrative bylaws. Perhaps by the time that I move from there to there, she'll remind me whether I'm supposed to be addressing that or you're doing that. So if there's anything else or any other questions, I'd be happy to be around to answer. Thank you all.
Good evening, everyone. Ed Kazanovich, Chief Financial Officer, Assistant Town Manager. Just a few matters relating to an area of finance that I'd like to bring to your attention that may apply to your boards and committees. First, I guess we can say that we can count on every year an annual town meeting that is set by the charter. As boards and committees, you may have articles of interest or consideration that you want to put before town meeting. The annual town meeting is set under the charter to be the first Tuesday in May. Following that, we do have an annual fall town meeting, primarily to address budgetary matters that may not be in place when we take a budget to the annual town meeting. Historically, the state budget is agreed upon after our conclusion in the annual town meeting, so there are a number of estimates and projections that we use in the model, and we have to fine-tune it once passage is made by the state. Given that, as boards and committee members, you don't have to wait until you're notified by a vote of the Board of Selectmen to open up the town meeting warrant. I think you can mark on your calendar that these town meetings are going to take place. Fall town meeting typically happens the latter part of October. The warrant is usually open 6 weeks prior to a town meeting. There are also periodic special town meetings that may require some action by a board and committee, but those are far and few between. They do happen periodically. As part of the general bylaws on the capital that may impact your committees, the new general bylaw does provide for a new definition of a capital item. It went from currently 5,000 to a minimum of 10,000 with a minimum life expectancy of 3 years. There are capital items built into the 5-year plan with a minimum balance of 5 through 2020. We recognize through the new general bylaws that the new definition and the new limits will be put into place for the capital we're receiving now, which is for FY 2021. In terms of budget, in terms of the regulatory boards, being the Planning Board, ZBA, Conservation, and Health, there is a general fund operating budget for the regulatory boards. In those budgets, there are considerations for training and education. We ask that you review that and work through your staff or liaison on the admin side to put in your request, especially for the upcoming fiscal year 17, since 16 is already in place. The budget kickoff is going to take place on November 4th, with budgets due in roughly the first week of January, if not earlier. So just a heads up on that. If there are any needs or concerns, please give it some consideration and work through your liaison staff person to make those needs known. In terms of other funding outside of the general fund, I know there are a number of boards that accept donations. There are special revenue accounts. There are revolving accounts established under MGL, especially for the Conservation Commission. There are revolving accounts established for the Board of Health. Whatever procurement is made, whether it be through general fund appropriation or through special revenue donations, revolving account, they all have to adhere to the provisions of Chapter 30B. Those limits are defined. If you have any concerns about that, I'd be happy to provide you some additional information, or you can go on the state procurement website and look at the limits as established under the law. They recently changed, I believe, in August of 14. As part of the FY15 budget, there are new limits. They were raised. If you have any questions, please call my office and we can provide those to you. And there are a few exceptions to Chapter 30B. They are defined. They are emergency related. If there's a threat to public health or some type of a disaster, there may be an exemption that applies as an exception under Chapter 30B. That's all I wanted to bring to your attention. I'd be happy to answer any questions if anyone should have any. Seeing none, I'd like to turn it back over to Town Manager.
Thank you. I had mentioned that there were a couple of department heads here, but I also want to mention there are a couple of other employees that are here, mostly beginning with M, so I must have just skipped the letter M when I did this, so my apologies. Mike Marino is our IT director and does a great job, maintains all of our computers, all of our systems, does a phenomenal job. Matt Benoit is our town planner. He is also the liaison to a number of the committees that are here tonight, so thanks for being here, Matt. And I also have Chris Hugo, who's taping this. And Chris, when do you think this will run?
When you want it to run.
Whenever you can get to it. Yes. Yeah, there are some board and commissions, and please, if you're on a board or commission or you provide liaison services and there is no representative here, or there are maybe one or two and some committee members weren't able to be here, let them know that they'll be able to get the whole training on our website, Chris, and online.
I'll put it on YouTube and they can download it.
Great. Because we want to that'd be great. We just want to make sure you have the information. And I have to say that we have a recently retired employee who's here, who's just phenomenal, done so much for the town, Lieutenant Mark Moss. Recently retired, and a huge loss for the department, but we wish him the best in his retirement. And I have to say, he is not going away in the capacity of being a resident, because he has been the chair of the Bylaw Review Committee, and I see Carmela there. Bylaw Review Committee, again, spent 3.5 years researching and going over the bylaws. They just did a great job. Mark chaired it. And Mark is now, happy to say, he is now the new Emergency Management Director. Thanks, Mark. And as the Emergency Management Director, he automatically is the chair of the Local Emergency Management Planning Committee. And I just want to take the chance to thank Roger Bellhumer for the last, I believe, 3 years that he has been the Emergency Management Director. He recently stepped down, and just want to give him our public thanks. He's done a phenomenal job. Big shoes to fill, but Mark's going to do a great job. He's been involved on the LEMPC anyway, so just wanted to make sure everyone knew that Mark was here, and thank him for his, Mark, 30 years of service to the town on the police department, so incredible. Thank you. Now, I just want a couple of things. Bob did actually go over the general bylaws, as did Ed, just a couple of the notes that I had. Just I think Bob might have said it, but make sure under the new bylaws to reorganize at the earliest convenience. I believe it used to read at the first meeting of the fiscal year, and now, based on the fact that sometimes it's hard to get a quorum, sometimes committees want to make sure they have a quorum, they have a full membership, not just a quorum, before they take that vote. We did revise the language in the bylaw to make it easier for you. But when you do reorganize, we would ask that you would let the town clerk know who your chair is, and she can let our office know, because oftentimes we send correspondence out through the chairs. We want to make sure that you get that information. So we want to make sure we have the chairs. And a reminder, you do need to get sworn in, whether you're appointed or elected. And there is a bylaw related to that as well. So just make sure you go to the clerk's office and get sworn in. Occasionally, we have a member who's been serving for a while and really hasn't been sworn in, so technically, we want to make sure, especially on a regulatory board or commission, that you're sworn in and your vote actually is a legal vote. And one other thing on the bylaws, you do need to submit a letter of resignation. If you are stepping off at a period that you're prior to your term expiring, you need to submit a letter of resignation to the town clerk. Oftentimes, we've seen letters come in either to me as the appointing authority or the Board of Selectmen as the appointing authority, but we can't fill that seat until we have a letter from you saying that you're stepping down. You know, we put the reasonableness test to that. If something happens, or somebody moves and we don't get a letter, we ultimately do fill that seat. But we are supposed to have a letter, so please, if that ever does happen, try to get a letter in. A couple of other things, just again with the frequently asked questions and what happens with boards and commissions, and what are some of the issues that you deal with while you're there. Some of the chairs have contacted us over the last several months with issues related to attendance. And, the question is, what happens if you have a board member or a committee member who misses several meetings in a row, several consecutive meetings? On a regulatory board, that's a huge problem because they have to take votes on certain issues, and again, they're regulatory, so there are certain requirements. So the chair, what we recommend, whether it's a regulatory board or commission or an advisory board or commission. Sometimes that creates a quorum problem. If the chairs could please let me know if it's somebody that I've appointed or the chairman of the Board of Selectmen know if it's someone that the board has appointed, so we can address it. The practice, while it's nothing specific and in writing, but our practice has been if someone misses 3 or more meetings consecutive and they don't have a, I don't want to call it a valid excuse, but a good reason for it, and there are good reasons for it. But if there is no reason for it and it doesn't appear that that trend is going to be discontinued, then the appointing authority may remove that person in order to put somebody else in that seat so we can get a quorum. And again, it happens with some committees, it doesn't happen with many, but when it does, sometimes we're, as appointing authorities, we're finding out about it several months down the road where there's been a lot of concern about meetings getting canceled and no one can get a quorum and they can't hold a meeting. Please let us know as soon as possible. We'll reach out to the person. We'll see if there's something we can do to help them, which will ultimately lead into my next conversation. Yeah, Camilla.
I'm just thinking, can you have a video call meeting or no?
That will be, yeah. I'll jump into that now because it's a good segue into that. There, as Attorney Hennigan mentioned, under Mass General Law, there is a provision for Board of Selectmen to adopt remote participation. And if and when a Board of Selectmen votes to adopt a remote participation policy, it applies to every board, commission, subcommittee on both the town side and the school side. So it is not specific to the board. It's not specific to any one board or commission. They were asked, I believe by the planning board, has submitted a letter to the Board of Selectmen asking them to consider this policy. A couple of years ago, the board had voted against the policy. Different board, different circumstances. The board has taken it under advisement, and probably in August, the board had asked us, the town administration, to provide a recommendation to them for a policy. State law does give criteria that have to be met. If the board adopts remote participation, there are certain criteria that has to be met by any board or commission that participates in remote participation. Most communities in Massachusetts have also adopted an additional policy that really specifies and further delineates when that policy can be used. And many of those communities have adopted policies that put a limit on how many times a member can participate remotely. Some put restrictions on regulatory boards saying that under state law, you have to be able to hear the person. You have to have audio, so you have to be able to hear the person who is participating remotely. Many communities, and we have recommended that to our Board of Selectmen here, if they were to follow, to adopt this, have recommended that regulatory boards have to have video, not just audio, because regulatory boards have plans that are in front of them, visual plans. And oftentimes, while everything has to still be sent to somebody in advance, whether they're participating remotely or at the meeting, you still have to have the full package in front of you. Oftentimes, applicants come in with additional information the night of the meeting that we have to make sure that that member participating remotely has access to that and can clearly see it. Other times, and it's happened on the Board of Selectmen, other times you are looking at a plan that you've been given on the week before and you still can't quite make out what's in that plan, and you need that applicant to actually come up to the table and explain that to you. So in order to make sure that participants on regulatory boards and commissions can really understand and see and make a judgment based on what they have in front of them, we have recommended to the board that they look into adopting if they adopt this policy, to extend that policy to mean that regulatory boards and commissions would have to have the video. In that case, Carmela, the audio would be for anyone participating on non-regulatory boards. If it gets adopted, there are a lot of different nuances to this, but you'd have to make sure it's clearly heard by everybody. If there are any technical difficulties, the chair would be required to stop the meeting, try to fix the difficulties. If they could not, they would have to stop that person's participation and put it in the minutes. So it gets rather complicated, but the Board of Selectmen has been discussing it for a couple of months now. They wanted to wait until after the town meeting next week to take a vote on it, because there is an article on the warrant to add an alternate member of the planning board, which may help with quorum issues. And by having an alternate member on the planning board that can look at site plan plan review, as well as, I believe, special permits. If that article passes, the board then wanted to revisit the issue and see if it was still necessary. The board, to my knowledge, as well as myself, has not received requests from any other board or committee to have this remote participation policy, but it might be a good time now that you're hearing it. If you do want to have this, or you do feel it's a good thing, get in touch with me, get in touch with Chairman Holstrom, or someone on the Board of Selectmen, and let them know what you think about it. Whether it will be something that you'd be interested in. Again, the law does specify what can be, who can participate as a member in this. It's not available to everybody. There are certain criteria that have to be met in order to participate. And at the end of the day, it's my understanding it will be up to the chair to agree to allow a member to participate, assuming the criteria is met. We also, if we do this, would need proper notification. Mike Marino, our IT director, would need to know, because he'd have to make sure that the room was equipped with what we need. So we are going to be limited on the rooms that could hold this for now. So that's just a brief summary of it. Stay tuned. I believe the board's probably going to take it back up in November. It's a challenging issue for them. I give them a lot of credit because they're really looking at it carefully to see what the pros and cons are and how it can help benefit the boards and commissions without actually reducing transparency that the public expects. A couple of other things, just maybe three other issues that get brought to our attention, and I just thought I'd bring it up today. We get asked by several boards and commissions, what happens, or who do we go to if there's an issue with an employee that maybe interacts with the Board of Commission or works with the Board of Commission. So under the charter, the town manager is responsible for the operations, management, and administration of all the town departments, with the exception of the police and fire, which in the town's charter, we have a strong chief provision, which means that the police chief and the fire chief are each responsible for the appointment of their own officers, as well as the administration, operations, and policy within their departments. So other than that, it falls on the town manager for employee appointments. So what we have recommended, and we had conversations with town council as well as labor council, if there is ever a concern or an issue or anything that a board member sees or has a concern with a town employee, please go to the appointing authority, which again, for anything other than police and fire would be me. It's complicated when it comes to personnel and employee issues. It's very complicated. We want to know, we want to be able to address it, but it can't be done publicly. So be careful as boards and commissions not to have discussion of employees. At public meetings, you have to be very careful. They have rights as well, and there are civil rights. And as our Labor Council has said, if a board or commission member did violate an employee's civil rights, they could potentially be sued, and they would be sued as an individual, not as a member of a board or commission. So just a word of caution. Let us know if there's a problem, we want to address it. We just need to be aware of it. And again, there are certain things that you have to go into executive session on and certain things that you can't. So we want to help guide you through this. But for the most part, just we want to make sure that we give you the support, we help address whatever issues you have, but it's done within the confines of the law, and that we protect our employees who deserve to have their rights as well. On that same topic, oftentimes when that does happen, just be aware we're not going to be able to come back to you and tell you what the resolution is. We can just thank you and tell you that it is being handled. We can't divulge personnel matters and employee matters. Oftentimes, there are separation agreements with an employee, and sometimes in those separation agreements, a specific board or commission has been named. And in that case, due to certain legal issues, there's always a reason for that, but there may be language that says that the board or commission cannot discuss the reason for the employee's departure, nor can town administration, nor can the employee themselves. So we would just ask that you would respect, if we do have those types of separation agreements in place and we have to get back to you and say, I'm sorry, we're not able to talk about that, that you understand why. let's see, one other thing under the charter, and just certainly as a matter of helping us to manage workflow, many of the regulatory boards and commissions have a staff person, an employee, who is their liaison assigned to that committee, so you can go through that person if you need anything. If you don't have anyone specific assigned to you and a board or commission needs to get information from us, we want to get that information to you. We want to get it to you in a timely manner, but we would ask that you go through either the appointing authority or the department head or the supervisor to get that information. It's a matter of managing workflow. So if you can't get a hold of the department head, please do go to the employee, get what you need for your meeting. We don't ever want to stop that. But what we do want to do is hopefully have a better understanding of what requirements are coming into our employees so the managers can manage that workflow. So if they've been asked for something, it's going to take a lot of time, and another supervisor assigned them something, they're going to be torn as to what to do. So we want to help you. It would help us if we know what your needs are, what your requests are, and we'll make sure that we get them fulfilled. So again, if you don't have anyone specific, go to the department head first. If you can't get the department head, always feel free to contact Ed or myself. We're always there willing to help any board or commission member get what you need. And if we can't, and you can't reach us, go to an employee. We want you to have what you need to run your meeting. And then we will figure out how to handle the workflow and how to get that information out to you as best as we can. I think that might be, one other thing, ACTV coverage, cable TV coverage. The Board of Selectmen, a couple of years ago, maybe 3 or 4 years ago, took a vote that they wanted every board and commission meeting to be televised, if possible. We've been trying to do that through Chris Hugo and all of our television camera people. Sometimes it's possible to do it live. There are only certain rooms that can go live. This is one of them. The planning board is one of them. If your meeting is in a room that can't go live and we have the available staff, we do have those meetings taped, and then we run them on Auburn cable television. If there's a specific meeting that we don't normally tape and you'd like us to tape, please let us know. We'll try to make arrangements and we'll get somebody there. We want to be transparent. We want to get information out to the public. We want to help you get your information out to the public if you're talking about an important issue. So again, if there's a coordination issue, if you need a different room, if you want it televised, give me a call, give Chris a call, call Ed, and we're happy to work with you to make sure that that gets televised. And I think just a couple of last minute things, just more on the social side. I just first of all want to let everyone know that we, the management team here at town, in town administration, we've been holding a holiday party for the employees every year. We started a couple of years ago just to thank them. It's an open house from 12 to 2, and it's usually the Thursday prior to Christmas. And a couple of years ago, we said, you know what, we'd love to extend this to the boards and commissions that we all work with. So we did send out letters last year. It is during the day, because that's when the employees are here. They can come up on their lunch breaks, and we have, it's very nice. We have the vocational school students provide a nice, just a luncheon buffet. It's a good experience for them. It's great for us. It's just a social event. It runs from 12 to 2 generally, and this year we just chose the date of December 17th, which is a Thursday. So you will get invitations, but we just wanted to personally extend it. It's a nice chance, just drop in, have a sandwich, say hello to town employees, to each other. It's just a nice time of year for everyone to kind of get together and socialize, because we don't get to do that very much. And also we do have a tree lighting, if any of you have ever gone to that. This is a community event. It's a great event. It's down right beside the fire station, and it's on December 4th. And while it has absolutely nothing to do with boards and commissions, while you're here as residents, I just thought I'd put in my, note that municipal aggregation is moving forward. If you haven't heard, you should all be getting letters in the mail from the town in conjunction with our municipal aggregation consultant, which is Colonial Power. And we were able to get through the whole regulatory approval process through the state. We were able to have municipal aggregation. Ed and I and Matt and Eric have been working hard with Colonial Power, and Colonial Power was able to go out to bid and get a rate of 9.522 locked in for 1 year. So National Grid's rate starting November 1 is 13.125, I believe, 13.126. So this is about 37% less than National Grid. All residents will be automatically in this program unless you opt out. So it is an opt-out program. If you don't want to participate, there will be information in the letters that come to you. There will be tear-off sheets that you fill out and get back to Colonial Power, and you can opt out. You can opt in at a later date. There's no penalty. So just keep your eye out for that. There's a lot of questions on it. It's a good program, but you may choose for other reasons not to do that. When we did the calculations, we figured that even if in the spring the rates were to drop, National Grid rates would have to drop to around 6.5% to even equal the rate that we were able to get for the whole year. So kind of keeping that in mind, they haven't hit that rate in about 5 years, so it could happen, but if it did drop to 6.5, you would be, if you were in the municipal aggregation program, you'd be at the equivalent rate that we were able to get all winter. The beauty of municipal aggregation is it keeps it consistent. It's a regular rate every month. So for planning purposes and budgeting purposes, you're not worried about what's coming your way. The Colonial Power estimated that each resident's probably going to save between $30 and $40 a month on the municipal aggregation plan. So I just wanted to use this opportunity to let you know that that is coming. The letters should be out in about 2 weeks. It's a good program. And I think, unless anyone has are there any questions or any issues we haven't addressed or you'd like us to address? No, nothing? All right, well, I just, once again, I just want to thank everybody. We are grateful to work with you. We're grateful to have you volunteering for the town. It means a lot. We couldn't do it without you. These boards and commissions are critical, whether you're regulatory or advisory. We absolutely need to have you on board. And we have a new one that we just appointed today, a 3-member golf advisory committee that we're going to wait to see which direction we'll take after town meeting if we are going forward with the taking over the Package Hub golf course, or if we're not. Either way, we need to have an advisory committee to help work with us and help us make some recommendations on how to proceed. So hopefully next year you'll see them in this training as well. So once again, thank you all. We're grateful to have you, and have a good night. Thanks.